Part 1. Namaskar to all. Let me first take this opportunity to thank Mr. Major General Nilendra Kumar ji for taking this initiative of starting the series Nurturing the Smart Teachers, and I would like to thank him for making me a part of this initiative. Friends, as you know, in India, the teacher-student relation is a unique relation. We have the system of Guru Shishya Parampara. The teachers, they nurture the raw minds of the students and they make them the human being. As far as teaching of law is concerned, legal profession is a noble profession. And that is why the persons who require to practice this profession must be the noble human beings. And the duty to make a person, a boy or a girl, a noble person lies with the teacher teaching the law. Teachers are or creates or makes the future of our country. Our destiny of the the destiny of our country is shaped by the classroom teaching by the teachers, and instead of saying the classroom teaching, we can say classroom discussion in the teacher. Teacher just not give material to the student in the class, they also take material from them. What the teacher did in the class or do in the class or is supposed to do in the class is they have to tell the law to the students. They have to teach them to analyze that law. They have to teach them how to apply that law to the particular situation, and they also have to inspire the students to think beyond that analysis and go towards the criticism or how it could have been made a better law or better interpretation of it. The content of the teacher, actually, most of it is derived from this classroom discussion. So teacher-taught relation is not a one-way relation, it is a two-way relation. Teacher tells in the class, inspire the students to raise inquisitive questions, and in answering those questions to the satisfaction of the teacher himself has to work hard. Teaching is actually persistent studying. You cannot be a teacher, you cannot teach in the class, especially law, unless you yourself undertakes persistent studies day and night, because law is always changing. It may not seem to be changing to the general public, but the fact is that the act which is enacted today, the interpretation given to it by various courts in different cases will be different, and that way it will keep on changing. So the application of the law keeps on changing from time to time, and that is why the teacher has to keep itself updated. As for the teaching skills are concerned, the teacher must be thorough about his subject, must know the concepts involved in the subject, must know the application of the law which teacher is going to discuss in the class, who are governed by that law, who are not governed by that law, and must be a good orator or a communicator. Unless a teacher communicate what he thinks to the class and explain it so that the students can receive it in the same wavelength in which it has been taught by the teacher, the teaching has no means. As far as teaching of law is concerned, just lecturing in the class has no meaning. Like in Delhi University, way back in the 1960s, The case method of study was adopted, and we cannot teach law without discussing the relevant cases in which the interpretation to the provisions of the statutes has been given by the judiciary, meaning thereby using the law, the written law, practically. That has to be taught to the students. And for that, for teaching law in the class, it is must that there must be eye to eye contact between the teacher and the student. Merely giving PowerPoint presentation or talking by some other mode, though such modes are being used during the pandemic times, because instead of not having anything, something is better. That is why new ways of teaching has been created, has been evolved by online teaching. But otherwise, in the normal situation, there is no substitute to eye contact in the classroom between the teacher and the student. This, in brief, is what I want to tell you about teaching. Now, coming to teaching family law. Family law is a very wide subject. To study family law, first of all, we must know what is family and what are the relations between the members of the family. Friends, family law in India, it is a very important and vital subject. Why it is important? The important lies in the fact that this is the law which start applying on a person the moment the person is conceived by the mother. It is this branch of law which will determine whether the child who is going to be born will be a legitimate child or illegitimate child. It continues its application day and night throughout the life of the person, and even after the death of the person, it continues to remain applicable as far as devolution of the property of that person by way of intestate succession is concerned. So this is the branch of law which applies before birth and continue to apply even after the death of the person. The branches of the areas this family law covered is very, very wide. It includes legitimacy of children. It includes maintenance of children, custody of children, guardianship of children, adoption of children. It includes marriage, law relating to marriage. It includes marital duties and obligations. It includes marital reliefs provided by the law, matrimonial reliefs provided by the law like divorce, judicial separation, restitution of conjugal rights, nullity of marriage, etc. It includes maintenance of spouses. It includes maintenance of parents. It includes maintenance of other relatives. It includes adoption by the persons. It includes succession to the property of a person who died leaving behind property, which is of two kinds: intestate succession and testamentary succession. The area of a family law is very, very wide, and it is a very important branch of law. That is why in all law schools, family law is a compulsory subject to be taught in 2 semesters. One full semester is devoted to the discussion of succession laws and law of joint Hindu family. And the other semester is devoted to law relating to marriage, divorce, other matrimonial relief, maintenance, adoption, custody, guardianship of children, etc. Friends, the study of family law is unique in our country. Why it is unique? Because unlike the rest of the civil law, Family law display a lack of uniformity in their application with the relevant criteria depending upon multiple factors, predominantly being the religion and the domicile of the persons, domicile of the parties, sometimes the domicile of the parents, and sometimes also the religion of the parties of the person to whom a person married. These laws have their roots in religion and in the custom. What I want to say is that in India, people belonging to 5 religions reside. Hindus, and in Hindus, we can include Jains, Buddhists, and Sikh. These 4 are the religion which are originated in India. Christians, Muslim, Jews, and Parsis, these 4 religion, the person belonging to these 4 religions, these religions have no origination, they were not originated in India. They are the foreign religion which have come to India, but the people belonging to these 4 religions also live in India. The law of all these persons belonging to these 4 plus 4, 8 religion was different, and it originated from the religious books or customs. That is why family law is also called personal law. It is personal law because it is personal to each religious communities. Hindus have their own law derived from Shrutis, Simritis, mainly from Simritis and the commentaries written on Simritis. And while writing the commentaries on the Simritis, what the writer, the jurists do, they incorporate the customary practices prevalent in the society in writing their commentaries. Just like commentary on a statute in today's time. Hindus have that law, Shastric law. Jains have their own Shastric law, Buddhists have their own Shastric law, and Sikhs have their customary law, which apply to these 4 communities. When the Christians came to India, they bring with themselves the Christian law. When the Muslims came to India, they bring with them the Muslim law. Christian law and Muslim law and Parsi law and Jew law also, they have originated from the religion. As far as Christian law is concerned, it is originated with Christianity, and Bible is the main, even Old Testaments, etc., are the main source of that law as interpreted by the Christian priests. As far as Muslim law is concerned, Muslim law, the basic structure of the Muslim law is the customary practices prevalent in pre-Islamic Arabia. With the advent of Islam, those customary practices which were dealt with or which were prohibited or which were contrary to what is written in Quran or what the Prophet Muhammad has said or approved or preached, were replaced by the Quranic law, by the Shariat. This law, Islamic law, is called Shariat law. Shariat is basically the law which is derived from Quran and the Hadith of the Prophet. So, in India, all these laws were prevalent, and in 1872 regulation, it was specifically said that in personal law matters, Muslims of India will be governed by Muslim law and the Hindus of India will be governed by Hindu law, and they will not be governed by the British law. So this practice continued even today, that different religious communities have different laws relating to family matters. Why these laws are different? Family is a unit of the society. Human beings, they live in the society. Family constitute the society. So the practices they follow based on the religion is the intentional practices they are doing. They have not been imposed on them by somebody. They are following by their free will. So Hindus were governed by their own Shastric laws and as amended by the customary practices prevalent. And the customary practices differ from India being a huge country. Customary practices differ from place to place, from community to community, from caste to caste. There were local customary practices, there were general customary practices, and there were even family customary practices. All were recognized as law. By the independence of, during the British period, very few statutes dealing with family law were enacted. And most of them were meant to be made applicable to all. Some were made applicable to all, while others were not made applicable to all.